All of a sudden, instead of one authority to concern yourself with, you've got dozens of relationships to build. The quest for regulatory certainty seems to have created a great patchwork of applicable rules and potential outcomes. It's a huge challenge, and it's going to require a lot of finesse.
Welcome back to the Environmental Evolutions Podcast. I'm your host, Linn Bumpers. Today, we're beginning a two-part series on EPA priorities and actions during the second Trump administration from former EPA attorneys. The first episode focuses on EPA's evolving enforcement priorities. I'm joined today by two former EPA attorneys from Baker Bott's Environmental Safety and Incident Response Group, Matt Morrison and Matt Trawick.
Baker Bott's LLP provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Before we start introductions, Matt Morrison is a Washington, D.C. based partner who draws on more than 2 decades at EPA and DOJ to advise companies facing complex environmental enforcement and compliance matters. He served as acting and associate division director in EPA's Office of Civil Enforcement and as deputy director of EPA's Office of Criminal Enforcement. Following 13 years as a trial and supervising attorney in DOJ's Environmental Enforcement section. Matt focuses on Clean Air Act matters, Superfund, and the Endangered Species Act, and counsels clients on EPA's current compliance first approach to environmental regulation. He advises and represents companies in the energy sector, including companies producing renewable fuels, and in the chemical sector, helping clients secure efficient and durable compliance outcomes. Matt Trawick is a senior associate in our Houston and soon our San Francisco offices, who joined Baker Botts after spending more than a decade as a civil and criminal enforcement attorney for EPA's Region 9 and Region 6. Those are in California and Texas. Matt served as lead counsel for compliance and enforcement matters under most of the federal environmental regulatory programs, with a particular emphasis on the Clean Air Act's Risk Management Program, RCRA, and Superfund. At Baker Botts, Matt helps clients facing the threat of enforcement through civil and criminal investigations, incident response, and compliance efforts. With that, this is the start to a conversation about the current enforcement landscape at EPA. Matt, what do you see as EPA's top enforcement priorities for the coming year? And how have those priorities shifted or remained consistent?
I think it's fair to say there's been an absolute sea change in how EPA enforcement priorities have evolved since Trump took office in his second term. And we're seeing that in 4 ways. First, we're seeing a broad shift toward deregulation and reduced enforcement, because after Trump returned to office, we've seen EPA make it very clear that there's going to be a pivot away from aggressive regulation and enforcement and moving toward a more business-friendly, deregulatory posture. And that's kind of a restructuring that moved the agency away from traditional enforcement and now is really emphasizing economic growth, energy production, and industry flexibility. The second way I think we're seeing things change, we're seeing on the numbers a dramatic decline in the number of civil and criminal enforcement. Some would say there's almost been like a collapse in civil enforcement actions. DOJ settled about 15 EPA-referred cases last year, far below what we saw in Biden's first year, 71, or even Trump's first term, where he had 75 cases. And the Clean Air Act enforcement has nearly halted, really, with only a single consent decree lodged, compared to 26 in the first Trump term and 22 under Biden. And the same thing is happening in Superfund and Clean Water Act settlements. All of that data suggests definitely a notable reduction in referring and prosecuting violations. Thirdly, we're seeing big cuts in staffing. Besides the early retirements, we've lost about 3,000 of 15,000 employees to buyouts, and other cuts are still proposed. I think Trump's 2026 budget calls for an additional 55% cut to the agency, which would be one of the deepest in history, but that's an opening bid as a budget. And I think it's really important to underscore that industry veterans know what's likely to fill that gap? It's going to be NGOs and states, sometimes stronger, harsher, and result in more of a patchwork approach to figuring out compliance. Lastly, in terms of a policy overhaul, there's been a rollback of the existing rules. We're seeing deregulation in energy, automotive, and other industrial sectors. We're keeping track on the 2009 endangerment finding, which the agency recently rescinded. On top of that, rolling back dozens of air, water, and chemical safety rules. All of these moves reduce the regulatory triggers that would normally lead to enforcement, which is another reason I think we're going to continue to see a downward tick in the numbers. Matt, anything else from you?
I certainly agree with almost everything that you've said, Matt. Although I think the rumors of enforcement at EPA being over with are greatly overstated. We've seen the compliance first memo come out. My question is compliance first, but then what? We've seen that certain large enforcement cases are proceeding. EPA, DOJ have announced some large settlements related to environmental enforcement actions. The work seems to be continuing, though certainly not on the pace that it has been in prior administrations. And we've seen OECA specifically speak to the administration's future enforcement efforts. Jeff Hall, who is the administrator for OECA, signed a memo called Implementing National Enforcement and Compliance Initiatives Consistently with Executive Orders and Agency Priorities. This memo clarified that while EPA was paring back some of the interpretation of its existing national enforcement and compliance initiatives, that several of them persisted. And I would call particular attention to the NECI related to chemical accident risk reduction. It has been a national enforcement initiative since at least 2016, and memo reemphasizes that EPA will continue to take enforcement action on facilities that are subject to the RMP regulations.
Yeah, Matt, I think those were great points. Even with a compliance first approach, enforcement is right behind it. The December 2025 compliance first memo signals that there is an opening for companies that are proactive in their training and use of self-audits and proactively correcting things. But enforcement does remain for those companies that don't heed that opportunity. Going back to that same memo, you see continued partnerships with the state. We might see states taking more of the lead, which they had in the first Trump administration, the kind of a right of first refusal, even if EPA sometimes develops the case. You're going to see better communication and a no surprises approach. It was very clear in that memo that the agency wants to move toward more clear expectations, transparent deadlines, and two-way communication with facilities. A critical piece of it is the whole notion of having unambiguous positions from the agency, from the administration on issues, and that the agency has to rely on what was called in that memo the most defensible and clear reading, and that ambiguities between the regulated company and EPA had to be escalated, which is really the first time that I can recall the agency ever inviting that kind of elevation. It usually was something that was left to the case team to figure out. And then lastly, finishing up on this memo, you're also going to see a very tailored injunctive relief. I don't foresee that happening. I think it's going to be very tailored injunctive relief as well. And as we heard earlier, the whole idea of supplemental environmental projects or mitigation is also likely to fall by the wayside in that more narrowly tailored approach to injunctive relief. So just adding that on to your good points, Matt.
Yeah, I think that's exactly right. But it doesn't mean that injunctive relief is going away. For example, the EPA proposed a new rule amending the RMP regulations, and in the notice of the proposed rulemaking, in various instances, the agency highlighted the importance of injunctive relief tailored specifically to enforcement cases. The posture seemed to be that we didn't want regulations that might be overbroad or not as generally applicable to all facilities that might be subject to the regs, but left in place and encouraged enforcement teams to consider injunctive relief, for example, related to third-party audits in individual enforcement cases. So the new administration does seem to embrace the idea of continued enforcement and enforcement that is specifically tailored to the particular situation at hand.
Agreed.
It sounds like there are different areas in which this administration is pivoting towards compliance first and narrowly tailored resolutions. But what aspects of enforcement do you see remaining similar to the way EPA has traditionally operated?
National enforcement and compliance initiatives are still in place. There's been talk by the agency of shaping and revising those to the administration's new priorities. But right now, the NECIs, as they're called, are still in place, and I think they're going to remain in place. And those cover things like PFAS enforcement, 112R cases. On top of that, keep in mind the national enforcement compliance initiatives are just a piece of what EPA does. There are the so-called core programs or core enforcement, Clean Water Act, discharge violations, Safe Drinking Water Act, Clean Air Act, hazardous waste management. All of those are going to continue. The agency, I think, will remain focused on those. Civil and criminal enforcement is definitely going to continue where non-compliance presents clear harm. This captures chemical accident prevention under 112R, PFAS releases, hazardous waste mismanagement. Self-audits and self-disclosure has been around for a while. The audit policy is almost 30 years old this year. And more than ever, there are big incentives to find, correct, and disclose actionable violations. The Pritzloff memo suggests that industry should not think enforcement has gone away, as Matt pointed out. That guidance makes it clear that for those who fail to correct or disclose, traditional enforcement still awaits, but it's a huge opening for the companies that become more proactive, increase audits, self-correction, and disclosure more than they've ever done and maybe been fearful to do. The administration will reward that proactive activity and candor.
It seems like this presents an opportunity for companies to re-engage with EPA on enforcement priorities. Matt, you mentioned that the Compliance First memo in resolving ambiguities encourages companies to engage with EPA leadership to resolve ambiguities that shouldn't be resolved at the staff attorney level. There are only so many EPA leadership positions to engage with, and so you're going to see a natural bottleneck with that process. And even after engaging with EPA leadership, the enforcement team on a case remains. They will continue, most likely, to be the team that sees the case through to its resolution. So I think there's value in identifying important areas of ambiguity that could result in consequential outcomes for enforcement. But the notion that for every enforcement action that EPA takes, a respondent to that enforcement action would be able to run it up the chain, get a quick determination that the case team has the wrong idea about the policy or the law, and then the enforcement goes away, that's just not going to happen. There's not the bandwidth for that sort of engagement at the upper levels of EPA. Earlier, bread and butter enforcement, things like RCRA enforcement, things like water discharges, there's not a ton of ambiguity in these run-of-the-mill cases. These aren't things that we would find much value in elevating to higher levels. So I think that the Compliance First memo certainly will have an effect. There's no question regional enforcement staff is impacted by the policies that come out of headquarters, but I'm not certain that it will be so broad in scope as to impact most of EPA's enforcement actions. I think the scope will be more narrow once the Compliance First memo is actually put into practice.
Matt, we all need to manage our expectations about how this new day of elevating ambiguities might work. While there are programs that are fairly clear on their face, we do find an ambiguity, and we're having an issue with the case team. The question of access to political leadership is yet to be resolved. The staffing is lean. The political team is as busy as any administration. So when and how people can elevate those issues remains to be seen, and whether the political management recognizes something as worthy of elevation as opposed to a call left for the trial team. These are new dynamics and things we're going to have to watch this coming year.
I heard you both talk about the bread and butter enforcement of Clean Air Act, Clean Water Act. About a year ago, Administrator Zeldin released the EPA's priorities behind powering the Great American Comeback Initiative. And the first pillar was clean air, land, and water for every American, outlining the priority to get back to those basics. So, in what other ways are you seeing EPA actions reflecting the broader policy directives from the administration?
There are a few ways. When you look at Administrator Zeldin powering the Great American Comeback Initiative, which again he announced in March of 2025, we're seeing that play out in three different ways. One, we're starting to see enforcement shift to emphasizing cost reduction and streamline regulatory expectations. But to Matt's earlier point, it's not that enforcement is going away, it's that the approach seems to be with a different emphasis. Secondly, I think the focus of the actions is going to increasingly focus on narrower statutory interpretations, and that's consistent with the Pritzloff memo, the compliance first memo, in terms of not being overly aggressive in how the agency is interpreting. And lastly, I think you've heard the administrator announce that the national enforcement and compliance initiatives are likely to be revised and reevaluated in light of the pillars of his repowering the American comeback. Exactly how they're changed, I think is still evolving. Some of the enforcement initiatives still call for greenhouse gas reductions. It's hard to reconcile that with the administration's efforts to rescind the endangerment finding. Granted, that was just for mobile sources, and we haven't hit upon stationary sources, but there's likely to be a reassessment of those enforcement initiatives as they litigate the challenges filed to that rescission of the endangerment finding.
I think another thing to keep an eye on, we've seen direction from OMB that is instructing agencies to use technology to streamline their processes and increase efficiency. In the future, EPA may be considering how to work artificial intelligence into their permit review and enforcement decisions. EPA is a data-heavy agency. For example, the RCRA enforcement program, there are troves of gigabytes, petabytes of data that a machine could go through. An enforcement staff person just can't. So if the agency is looking for technological solutions to problems, we may see the evolution of certain enforcement programs, and who knows what may come of that.
Matt Trawick, as an enforcement attorney for both Region 9 and Region 6, how are you seeing the regions responding to the changes coming out of DC?
With every change in administration comes a change in policy, and those changes make their way down to the enforcement staff level. There can be hard changes in policy, the written policy changes, and softer changes in policies may reflect the priorities of a particular individual, of regional staff, of headquarters staff. So it really depends on the particular policy and the case on which it's being implemented. The regional staff is less focused on the kind of academic approach to policy, right, nationwide policy, and more concerned with where the rubber meets the road when it comes to a particular enforcement case. Regional staff respects and implements policy as they are directed to do. That is a part of their mission and a part of their obligation. Policies are general and enforcement cases are specific. So regional staff rolls with the punches. And I think, Lynn, it's hard to overstate the shift that we've seen in regional staffing and staffing across the EPA and the government more broadly. Regional staff is being asked to do more with less. We've seen departure and staff turnover at EPA. We're going to see newer and probably less experienced staff, which may result in a decrease in enforcement. On the other hand, that may mean we have inspectors that need to be credentialed, which means they need to go on more inspections, which may result in an increase in the number of inspections and potentially an increase in the number of enforcement actions. So it's really unclear how any particular policy will be implemented in any particular case, except to say that regional staff do their job. They respect the policy and they apply it as they believe it should be applied.
So do you have any recommendations for companies engaging with these regional regulators that are having to do more with less?
They should call Matt Morrison and have him help out. I think the smoothest way to deal with an enforcement matter is to speak to the regulators in their own language. Regulators are limited in what they can and what they can't do, and they are bound by certain policy documents, whether it's a new broadly applicable policy, or it's a down in the weeds penalty document that hasn't changed since 1983, and that's how they calculate a penalty or make a leveling determination on the extent of deviation or potential for harm of a violation. Being able to speak to regulators in their own language is extremely valuable, particularly when they're operating with limited resources and limited bandwidth. The more readily you can speak to them in their language, the more likely they are to be able to move in one direction or another.
Yeah, I would just add to that the regions are expected to be more deferential to states and give the lead to states besides focusing on communication with your regional EPA regulator. But I think it makes sense for companies to strengthen state level relationships and understand the state interpretations, which could drive much of the practical enforcement landscape in the next few years. The other thing, the use of voluntary audits and the whole find and fix framework to demonstrate good faith compliance before it escalates into enforcement, that invitation is there, I think, in the regional level as well. And I think it makes sense for companies to heed that.
Absolutely. Developing good relationships with the states will be critical. I think it's fair to say that the state of California, for example, saw the departures in staffing from EPA as an opportunity. We saw a lot of EPA staff go into a state counterpart agency. So states are certainly gearing up to fill what they see as potential gaps that EPA has stepped back from. And that's going to manifest itself in a lot of different ways depending on the state. And so, Matt, you're exactly right. Having a good relationship with your state regulators is more important than ever.
Yeah. One other thing is the role of NGO and state enforcement activity, especially in state. There's a track record, even in the first Trump administration, of record fundraising in the NGOs and lawsuits filed. It is happening. It's going to continue to happen. What do you do about that? Most companies don't have relationship with NGOs. How do you prepare for that patchwork approach from different states and NGOs? Matt, what do you think? I think that's a question that comes up a lot.
I think it's more of a you question, right? It's kind of a nationwide, not that I want to pass the hot potato, but what do? You start building relationships. All of a sudden, instead of one authority to concern yourself with, you've got dozens of relationships to build and monitor. And we are seeing the quest for regulatory certainty seems to have created a great deal of confusion and a patchwork of applicable rules and potential outcomes. It's a huge challenge, and it's going to require a lot of finesse.
Is there a connection between the rise in citizen suit enforcement and the use of the self-auditing tools that EPA is encouraging more in this administration? Is that one avenue for companies to, in addition to building relationships with their community and having engagement, taking internal self-audit steps to protect themselves from enforcement in those areas? Is that a tool that industries can be using as well?
That dynamic has existed for years. The concern of companies who do self-audit and disclose, if the agency doesn't come after them, someone else could. A lot of audit disclosures are now made through a confidential portal at EPA. I don't know the extent to which citizens can get at that information. I'd imagine, absent a claim of CBI, confidential business information, it is subject to FOIA release. What I've seen is a lot of citizen suit and NGO enforcement tends to focus lately on macro problems at the agency, rulemaking, deregulatory type of actions. I don't see a lot of NGO and citizen suit activity on the one-off permit exceedance or you miss your air emission standard. I'm seeing them putting their funding and resources into pushing back on the larger deregulatory elements of the administration. So I don't know if I would say that fear of citizen suit enforcement or NGO enforcement is a basis for missing the opportunity to focus on the invitation that's out there with this administration to audit, self-disclose, repair, and have a relief from enforcement. I still think that's the smarter path. And I think a lot of the NGO focus is going to be on trying to push back on the deregulatory aspects, the macro deregulatory aspects of this administration.
Thank you again, both to Matt Morrison and Matt Trawick, for sharing your valuable insights and expertise with us today. I'm looking forward to continuing to monitor the evolving landscape of EPA enforcement, and I really appreciate you both coming by today.
Appreciate it, Lynn.
Thanks, Lynn. What a treat.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts, LLP, for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.